exciting to be here again, like every year, and I'm very much looking forward to a great panel with four distinguished experts on SEPs. So we have even split between lawyers and economists on the panel, and that should be reflected in the topics that we will talk about today. So the topic of the panel is global SEP disputes and FRAND frameworks. As I think everybody in this room knows, it has been a very busy and exciting year with SEP litigation, and we want here in this panel to take stock a bit of what we have learned and what are still the problems out there that need a solution. So at a general level, the structure of the panel will be that we want to start reviewing just a little bit, very quickly, what are the main things that have happened, what are the core themes that emerge from that on different sides and different sides of the world. So we have somebody from the UK, Richard Brigney, who will introduce some of the topics from Europe, and then Ryan Cunningham will offer perspectives more from the US. But the idea really is just to be short, provocative, and raise questions and topics for debate. So we will discuss the main themes that emerge from that. Then, after maybe half an hour, we're gonna try to move on to ask, okay, given that there's so much action and there's so many things that are emerging from these cases, can we actually see that we're progressing towards implementing FRAND in a way that we're getting closer to implement and to reach what FRAND is actually supposed to be doing? And so we are asking, what is FRAND supposed to be doing? And we have the economists who will lead the discussion for that. And once again, in the spirit of being provocative and raise debate, and then we can discuss this as well. And then last sub-discussion in the panel, the institutional questions. So we have facing a world in which different courts setting different rates and different places in the world are nudging parties towards arbitration. So we are asking the question, is on the institutional side what we're seeing helpful? What are the things that need to be done to resolve disputes in this day and age? So this is kind of at a very high level what we're trying to do today. Just maybe one short 30 seconds of publicity for something that we have done is that we have a report coming out just next Wednesday, written for the European Patent Office, or together with the European Patent Office.
Recording in progress.
Where we're, thank you, that's very important right now. Where we're taking stock of what, from 69 court decisions, what are the methodologies that have been used to determine FRAND or assess whether licensing rates are FRAND. So that's hopefully a useful resource that will be made available next week. So please have a look for that, and hopefully you find something interesting. And if you have something that you disagree with, then don't hesitate to let us know. But with this, maybe we turn to our panel. Richard, why don't you set us up and basically start the panel with your thoughts on what you think the main highlights of this year were in terms of SEP litigation, primarily in Europe, and what topics and themes and questions emerge from that.
Thank you. Yes, very happy to. I think it's been quite a big year, about 12 months across the world. But as far as the UK, the EPC, and Europe is concerned, I'm going to focus on three significant developments in FRAND disputes. The first is the UK decision in Samsung and ZTE, and of course that wasn't the only court deciding that case. But I'll look at that decision and compare and contrast, and that's really on the topic of substantive FRAND valuation. The second update is in relation to the Acer-Nokia dispute, which I'm sure most of you are familiar, and the issue there is arbitration and effectively institutional design of disputes and choice of forum. And then the final is the well-known Digital and Amazon ASI battles, which goes to really, again, the question of jurisdictional conflict and interim relief. And I think what all those developments are really highlighting in terms terms of resolving FRAND disputes is that the courts are really evolving in the journey in the FRAND framework. We're moving past simply determining FRAND. We're now determining FRAND, but also courts are competing to determine FRAND and looking exactly at the right process in order to reach an amicable outcome between the two parties. So starting with Samsung and ZTE, as everyone well knows, this was the fourth iteration in the UK of FRAND determination and was the first time the cross-license was determined with a net payment of almost $400 million in favour of ZTE. Now at a high level, the court does something quite familiar, which is adopts the comparable-based methodology, but it also considers but rejects a top-down approach, which is a first interesting point of distinction because not all courts do reject top-down approach and other courts do embrace it. And the principal basis in that case for rejecting it was on the facts of the case. It was deemed that the assumptions necessary were too sensitive to be reliable. And then finally, also on comparables, the court selects a single best comparable, in that case the ZTE aqua license. And again, that's the topic, selection of comparables, which is interesting. So I think two key points come out of the case which are interesting. First is the questions arise as to what is a good comparable license in the analysis. And in this case, different comparable licenses were relied on in different proceedings between the same parties. And in this case, in the UK, a number of potentially relevant comparable licenses of both parties were rejected, and each for different reasons. So just by way of example, Samsung's licenses, and Samsung was the net licensee, three very big licenses there were dismissed for amongst other reasons, effectively undue injunction pressure, and owing to some expert evidence for having very different portfolios. And so that was a key issue in distinguishing those licenses, for example. On methodology, the court also did something quite new here, which was to do an unpacking exercise which really tried to tie it to the real world circumstances of the relevant comparable licenses. And in doing so has taken into account what the court refers to, and maybe this will become a phrase used more often, as non-FRAND factors that were found to exist in those comparable licenses. And those distortions, in the view of the court, were because, for example, it was found that ZTE had a relatively weak bargaining position in negotiating some of those comparable licenses, and it was under pressure to conclude early deals owing to the financial circumstances prevailing at the time. So what the court actually did was identify those factors, but also in the unpacking tried to adjust for them. So for example, a first license discount effectively was given to reflect the fact that it was deemed that ZTE obtained value in entering a license first, and the consequential benefit to ZTE on having that first licensee signed up. An adjustment was also made for ZTE having a relatively weak bargaining position and end result in the eyes of the court on 5G. And finally, an adjustment to account for the fact that because of the circumstances of ZTE's financial position, the court found effectively it gave a big discount on past sales and didn't recover full FRAND rate on the past sales. So I think bringing that all together, Samsung and ZTE, comparables is in the focus. I think I've identified three key questions that perhaps we can discuss now or in due course. First is the relevance of top-down versus comparables. Is top-down remain relevant at all? The secondly is on comparables selection. As FRAND determinations become more common and the availability of comparable licenses are more available, more important is going to be the question of how to assess the relevance of comparables. How comparable are they? How many do you pick? And how, once you've picked them, you might make any adjustments. And that is the third topic, adjustments on comparable licenses. So, Eustace, I don't know if you want to pause to talk about that, or I can continue on the other.
I think that's a great idea. I mean, so then we keep it a bit interactive and we have questions that are good questions for the economists on the panel, I guess. So status and role of the top-down, selection of comparables, which I think divides into two sub-questions. I mean, first of all, this idea of selecting one comparable rather than deriving a rate from a more comprehensive set of comparables, and then very different approaches in different courts how to select and which comparables to select. And then, given that in all courts there was an agreement that none of the licenses was directly indicative of the FRAND, right? How do you adjust for what you call the non-FRAND factors? So these are kind of three core methodological themes that emerge from this case. So maybe we hear from the two economists what they, whether you have thoughts and responses to that.
Go ahead. Well, all I'm gonna say is I actually have a question. The technology's on, I think. My question is, and it's really a question for lawyers, so I was asked you. As an economist, I would say it's almost always wrong to throw out data, or at least it's inefficient, and other things equal to like last. And I observe a similar principle in legal cases. So if you look at a car accident, you would say, there were 15 witnesses to the car accident, but let's take the views of the one witness who we think is most credible and throw out the views of the other 14. You would accommodate them and recognize they're going to contradict each other in some ways, but it's part of the truth-seeking exercise to make use of the available information. So my question is there something about this process that where courts justify from first principles reducing this in the first instance down to one license, and then trying to adjust that one license? Is that a reliable legal method? Because to an economist, that sounds nuts.
I think one license is not always going to be the right method. I don't think there's one size fits all way to approach a comparable license analysis. I think the job of attorneys in those cases is to try and put the licenses that do exist into context for the court. So was this license the result of they were facing an injunction, and how do we view that license because we know the person who entered it was going to be excluded from a major market? Is this a license that was reached purely through negotiation with a large company that had the leverage to fight if they wanted to? Those are the licenses that are going to end up being probably the most instructive of what a sort of free market transaction is going to be. What we've also seen as we've done these cases is that large SEP owners will oftentimes approach very small companies that don't have a lot of leverage, don't sell a ton of product. The cost to pay a license at a per unit rate that is way higher than what a large player is paying is still lower than the cost of fighting a litigation. And so they'll agree to terms and they'll stack licenses at what they'll call their sort of stock rate, their publicly offered rate. But that's not what most of the players are paying. So you have to dig into that factual scenario, see how many of the licenses are these sort of for show licenses where there was no real leverage, how many of them were sort of done with the gun to your head of an injunction, and how many are real transactions where both parties agree this is the FRAND rate. So I don't think a one license approach is usually or always the right way to go. I do think you need to put every single license into a broader context.
If I can add a little bit, unless you and Rich. Hi, thank you. In a rare turn of events, at least two economists are in total agreement. And it's rare for John and I to be in agreement, in addition to the general economists to be in agreement. But I'm with you, and I actually might have a slightly stronger response than yours, Brian, and that is, I don't think it's ever the case that only one license can be used as a benchmark. I'm probably wrong, but I think it's extremely rare. My hypothesis is that the court there and the courts in other instances do it as a matter of convenience. It's just easier to start unpacking one license than it is to unpack 6 other licenses. But like John, I'm a believer that the more data we have, the better our analysis can be, and the more grounded our conclusions can be. I'm also a firm believer that comparability is not a 0-1 proposition, it's a degree. And so for the court there to say there is a comparable license, but I need to adjust it, is a bit odd, because the court is saying it's not really comparable, I need to adjust it. So in some regards, each one of us is comparable, but in many regards, we're quite different from one another. And I think it's the task of the economist, among others, to unpack and compare and contrast the licenses with one another. So I think I understand it's judicially efficient to look at one license. I don't think you get necessarily to a better conclusion. I do have an observation on the top down as well. Many courts, as maybe you'll be discussing, use it as a reasonableness test. I think that seems sensible. For the court in ZTE Samsung to conclude there are just too many assumptions underlying the top-down approach as to find it useful was a bit odd to me, because there are lots of assumptions in looking at license comparabilities as well. Any analysis has pieces in it that are subject to different interpretations. So to just throw that out because it's assumption-driven would result in throwing out almost any observation in any litigation.
Yeah, we haven't told our audience that we're actually taking 3 hours for this program.
I think that was a comment on my comment.
So we have covered one of Richard's 3 questions that he wanted to cover. So maybe in light of the time, maybe we switch order and we go to Ryan and hear from Ryan about the main themes emerging from the US, which I understand are primarily concerned about access to courts, which then also plays into the main themes emerging from the 2 other cases that you mentioned. So maybe we can first hear from Ryan, and then you can comment on it from the European perspective. So just to make sure we cover the broader geographic ground in the limited time.
That's exactly right. Unlike some of the cases in Europe where you're looking at what methodology are they applying, in the US the major issue is if I'm an implementer and I want to take a RAND license, I want a court to set a RAND license, what the terms are, what the FRAND rate is, what all the other terms of a RAND license might be. Can I get a court to do that? Cases coming out of the UK, they've said we can set, we have the authority to set a global FRAND rate, set the terms of a global FRAND license. It's a little less clear in the US. There certainly have been US courts which have undertaken that exercise, but what we've seen through the Roku Access Advance case earlier this year, and a few other cases, that increasingly US courts are saying, I don't have the authority to set a global FRAND rate. Primarily that's driven through viewing these as territorial patent issues, which personally I think is the absolute wrong framework to view SEP issues. Certainly the underlying issue is there a patent being infringed? Fundamentally, these are contract cases. There, is a contract with the standard setting organization saying I will license my patents on FRAND terms. And if I'm an implementer trying to get a court to set a FRAND license, that's specific performance of a contract. I'm trying to enforce that contract as a third-party beneficiary. And U.S. courts recently just have not viewed that as anything other than, should I set the damages for these patents that may be infringed in the US? And that was the primary rationale in the Roku case. Most of these rights, or only a small fraction of the rights at issue were US patents, and therefore somehow that takes away jurisdiction to hear this contract claim. Another big problem here is that there are very few US-only SEP cases. Almost all of these standards are intended to be used globally. Most of these large companies sell products globally. And so you don't just have US-only disputes. You might try and bring a dispute in the US, but the SEP owner is almost certainly filing for seeking injunctions in Germany, in the UPC, in Brazil, in Colombia. They're always trying to find new venues where they think they have easier access to injunctions. And those cases, by and large, move a lot more swiftly than US courts. In the Roku case, Roku filed an appeal of the district court's dismissal of their claim. And I think less than 2 months later, they were facing a preliminary injunction in Germany, and so they had to settle, and that was dismissed. So there was no opportunity to get clarity on what the standard should be for U.S. courts to adjudicate those cases. I think another major factor that I think was actually missing from the slides earlier, looking at injunctions in terms of district courts is the wrong lens if you're looking at SEPs. Those fights aren't being had in U.S. district courts. Those fights are being had primarily the U.S. International Trade Commission. Most products are being manufactured overseas, imported into the U.S. The Federal Circuit has pretty recently clarified that if FRAND means anything at all, it's that you can't get an injunction without having negotiated in good faith and offered a FRAND license. Well, the ITC had individual administrative law judges that have said, even if there was a violation of their FRAND commitment, that doesn't factor into these statutory public interest factors, and so we can still grant exclusion orders. Now, those cases almost always settle before either the Commission or the Federal Circuit has a chance to clarify that standard, because the threat of having all of your products excluded from the US market, it puts its thumb on the scale so heavily that you almost have no choice but to settle at that point if you're facing an exclusion order. So there really is, I think, an opportunity for US courts to clarify what the standard should be for exclusion orders at the ITC, and whether implementers should have access to get FRAND rates set in US courts. But right now, it's very much up in the air.
Thank you, Ryan and Richard. So if we can pick between the two remaining cases that you wanted to discuss, maybe let's talk about Nokia and Acer. Because it touches on very similar questions, the implementer's ability to get a court to decide on if they wish.
Exactly, and I think this this topic goes to the real heart of the kind of broader issue at the moment, which is, I mean, disputes have evolved. When I first started working on FRAND cases, implementers were not interested in taking a license at all, right? And they would just hold out. Whereas now what's happening is implementers are saying, okay, hang on a minute, right? These are big portfolios. I'm going to be injuncted somewhere. There's just a dispute about the terms. And so now we're seeing implementers proactively trying to come to court or reactively trying to come to court. So it's a big question between the availability of injunctions and having a tribunal, whether that's an arbitration tribunal or a court determining FRAND terms. And that's exactly the background to the Acer-Nokia dispute. There were ongoing cases across the world where Nokia was seeking injunctions, and Acer, amongst other things, filed a case in the UK to have the UK court determine the terms of a FRAND license between them, including seeking relief in the form of a temporary short-term license, so-called interim license, to protect it from injunctions worldwide. And fast forward to the Court of Appeal decision recently, effectively Nokia's strategy in that case was to say, well, okay then, you can have a short-term license. Here it is, you can pay us an amount, and the final amount that you need to pay for FRAND terms will be determined in arbitration, and put that license on the table. And what Nokia did was ask the court to find that that license I've just described was a FRAND license or RAND license in that case. And effectively what the court did was said, yes it is, right? So that is a RAND license without question, and there was no prospect of Acer arguing in final trial that that was not a RAND license, notwithstanding that it hadn't got all the terms agreed. There was just an arbitration clause in there. And the consequence of that was the court was therefore not willing to progress the case that Acer had started for a FRAND determination in the UK. So effectively Nokia had given Acer a choice, which was enter into this license, which effectively compels arbitration, albeit you're agreeing to enter it. Or if you don't want to enter it, that's fine, but there's going to be no UK case and no UK FRAND determination, and all the parallel injunctions will be carrying on across the world. So that's the update on the case, and I think there are some interesting questions arising out of that, which is the power of the SEP owner to be able to dictate for him in that case.
to the order we wanted to achieve in this panel. Let's park these questions about parallel litigation and the choice between litigation and arbitration to the third, the institutional angle, and let's now turn to the economic perspective. So we already heard some economic commentary on specific methodological aspects that came up in the most recent decisions, but given that there has been such enormous amount of writing from the courts about FRAND rates in the last few years, and we have tried to compile a little bit of that, and Whitehall has also just produced a study trying to compile a bit of that. So like there seems to be a little bit of consolidation of things that we are learning from the courts, from the FRAND determinations, FRAND assessments done by courts. So I think it's a good moment to take a step back and ask the economists whether we are on track to achieve what FRAND is meant to achieve. So whether it's apparent progress, but not in the right direction, or whether it's real progress and we're implementing FRAND in a good way. So maybe, John, maybe you can kick us off by reminding us or telling us what FRAND actually is about, what FRAND is meant to achieve, and then we can maybe together with Jonathan develop it a little bit further, and then hear from the lawyers whether they think that this is useful and reflected in the decisions that we've been seeing over the last few months.
Sure, thank you, Eustace. You're probably right, this is a reminder to almost all of us in the room what FRAND is intending to achieve, although it's never codified or laid out explicitly, but when one reads the literature in court cases, one can tickle out three particular areas that FRAND is oriented to. That is enhancement of innovator, or let's call it patent owner welfare, by doing three things: allowing for adequate returns on investment, so a high enough rate, promoting adoption of the standard, reducing transaction costs, and giving some level of certainty. The second category is it appears that FRAND is intended to enhance implementer returns through four things: preventing holdup, so the rate shouldn't be too high; not allowing for returns associated with standardization or adoption of the standard; reduction of transaction costs; and again, some certainty, some predictability. Last, it appears that FRAND is intended to enhance consumer welfare through two mechanisms. The first is promoting technology adoption more broadly, and the second is encouraging effective implementer competition. So those are the general themes as I see, and I think John is going to drill down on some of those.
Right, well, so, first of all, I think it's worth noting the irony that we're gathered here in the Institute of Peace Studies. And I say that advisedly because I feel like as I step back and look at the sort of system of compensation for innovation that we're talking about here, I think there are structural problems that make conflict inevitable, and so as an economist, I'm kind of interested in trying to reduce those barriers and make the system more efficient. So here's what I mean by that. If you work from first principles, you have to agree that a standard is an economic good. It's an input into a product, and it's something that every implementer relies on and takes advantage of in producing a product. Like all other inputs, you have to be able to cover the cost of that input, or otherwise the input ceases to exist. You don't have economic equilibrium in the absence of a price that at least covers the cost of the product, which means that since the standard is created via R&D, the compensation for creating a standard has to cover the R&D that went into it. Now that sounds like an uncontroversial statement, but it turns out to be quite controversial. And that's for the third reason. So when you say, what do you mean by the R&D that went into the standard? You have to recognize that a standard development organization is both a monopolist, means it's a single buyer of the technology, and it's a monopolist, it's a single seller of the standard. So, and it's conducting a tournament. And in tournaments, like tennis tournaments or golf tournaments, there is a winner and then there's a whole bunch of losers. And in order to induce participation in the tournament, you have to offer a prize that's big enough so that everybody will enter the tournament, including all those people who will lose. So for example, suppose you've got 4 people who are entering a tournament. Each costs them $1 to enter the tournament. Only one of them can win. Let's say they all have a 1/4 probability of winning X ante. What's the prize you need to offer to the winner of that tournament in order to get him and all of them to enter into the competition? The answer is the prize has to be at least $4 because you have a 1/4 probability of earning $4. So your expected value is $1. That was your cost. That's the minimum reward necessary to enter into the tournament. The problem with that in the FRAND context is that means that if you are the winner, your patent is selected into the standard, everybody else isn't, and the proper compensation that you should receive is the tournament winners competition, which sounds an awful lot in a damages context like a supra-FRAND rate. You no longer are comparing the value of the invention to its next best alternative, you're comparing it to the prize that was necessary to induce the competition that you yourself have set up. And the problem with the institutional environment that we can talk about this later on, with the institutional environment we've created is that courts and regulators have no idea how to think about this problem, such that the aggregate compensation that is paid to R&D performers in order to conduct the competition necessary to create the standard is sufficient to cover their costs. If you knew that number, you could treat that as being the top in a top-down rate because that's the share of the handset or terminal unit's cost that would cover the R&D that was necessary to create the standard. But computing that turns out to be quite difficult to do, and awarding an individual innovator for a winning patent turns out to be something that courts are loath to do because it looks like super normal profits.
Yeah, so before we jump to the lawyers and reactions, I mean, maybe a comment from my side. So when we come through the E69 decisions, one thing that we noticed is that there had been 2013 or 14 in the first round of decisions, a lot of debate in the courts about what FRAND means, and you had a lot of theoretical, intellectual contributions on that level of the debate where it was possible to test questions about what FRAND was, and we seem to have converged on consensual formulations such as it's a balance, it's avoiding hold up and hold out, you know, these kind of relatively fairly general statements, and then move pretty much directly to the more methodological layer of the determinations. And you could interpret that as progress. We're progressing towards the specifics, or, I mean, you could take the position, hold on. I mean, for example, one thing that is systematically excluded from consideration is the cost. I mean, that's something that courts have been quite explicit should not be considered. So, I mean, it is an interesting question to say, well, are we actually consolidating on the wrong thing? I mean, so that's something that I would really like to give to the lawyers as a question, whether they agree with that framing, first of all, and then second, whether they are concerned with that, or whether they think we're actually, there are good reasons for the cases to be decided the way that they are.
Well, first and foremost, I think John's description of the purpose of the FRAND commitment is missing a little bit of important context, which is why it was introduced in the first place. If I were without the context of all the experience we have in FRAND, walked up to a lawyer and said, hi, I'd like to get together with all of my competitors and all the research institutions in my area. We're going to pick winners and losers in the technology, and we're all going to agree to sell products that incorporate only those technologies. That lawyer is thinking, my competition law department is going to get paid for so long. This is a massive competition issue, getting together, picking the winners and losers in the industry, whose technology is going to be used and whose isn't, and agreeing that's all we're going to use. And this isn't a novel idea. The European Commission had the same impression in the early days of ETSI and the ITU standard setting process. And part of the reason the FRAND commitment was introduced into those standard setting organizations was to try to balance the harm that could come from picking winners and losers in the technology with the benefit that you get from having a compatibility standard so everyone can make products that we know can interact with each other. And you're not fragmenting the industry into little proprietary domains. And so I think keeping that high-level picture in mind, there was a real recognition that it could harm the other competitors in the industry by getting together and excluding technology. I also think one sort of important framework stepping outside the FRAND context is companies invest in R&D without the promise of compensation all the time. Almost every company, their R&D has zero guarantee for return at the end of the day. There's no guarantee they'll have that R&D will turn into a successful product that is accepted by the market, and they get profit back from that research. And so a lot of companies are investing this in the hopes that they will have their technology adopted either into their own proprietary products or into these standards, but there's never any guarantee of a return. So there is a risk that everyone is undertaking that process that I think needs to get factored in, even in that framework that you were laying out.
So I think that just to that, commenting as a lawyer, I mean, I agree with, I can't disagree with the economic principles that you've articulated there, and just as I agree also that the courts have engaged only probably at a very high level as to how that kind of impacts what the courts have to do. To give an example, balancing hold up and hold out. But if you look at what's happened in practice in courts around the world, a couple of themes have developed. One is effectively FRAND is a process, right? And courts have adjudicated on the appropriate behaviour in negotiations with that goal of trying to balance hold up or eliminate hold up and hold out. But one arguable criticism of that process is it doesn't argue the fundamental question of what is FRAND, right? And how do you value a portfolio and the terms for that portfolio? So that which leads to the second point is FRAND as a thing, as a term, as a set of terms and conditions for a license. And where the courts have engaged there, I mean, I think potentially there's more that they could do on the principles that you articulated. And I don't know if it's if they're sidestepping the question or how you would express it, but the way they're going to those value questions is through the market, right? They look at the market and say, well, what is the market bearing for this particular portfolio that I'm looking at? And that's why you see the elevation and the prominence of the comparable license approach, because the court is effectively saying the best people to judge the value of this portfolio is the market itself. And that comes back to the topic we discussed earlier, and like how good that is as a proxy depends on how good the comparables are and how well reflective any individual or group of comparables is of a truly negotiation between a truly willing licensor and a truly willing licensee without hold up and hold out, and that is the challenge. And I don't think it's a perfect science.
And I mean, it's also worth pointing out the circularity of the argument, because you basically say FRAND is what a willing licensor and the willing licensee would accept, and the willing licensor is the one that would accept FRAND, right? So like it's really hard to really go from there to anything that is anything a little bit more specific. So it's almost abstract by design and by necessity.
Can I add one more thought to that FRAND as a process? The process, the information is asymmetrical during that process. SEP owners know what their licenses say. Almost in every case, if you're negotiating as an implementer, you have no idea what that SEP owner's licenses look like. They have confidentiality agreements. Within those licenses, they often can't disclose them either at all or heavily redacted, and that's in rare cases. So you're often trying to participate in this process as a willing licensee, but you can only see half the cards. You don't know what the other half has. So you are, fundamentally gambling with, I think I have a methodology that I can justify, but I have no idea what their licenses say. So I'm trying to kind of guess what their licenses might say to figure out if it's worthwhile to go and fight this in court and try and get a lower rate. And what exactly a FRAND rate is based on what would be non-discriminatory is something I can only guess at.
But as an implementer, I know who I've paid for other technologies and what.
I mean, that's certainly true, but a lot of times, in the video codecs, a lot of litigation going on right now in the video codec space, and what we've seen is that 90% of the video codec patents are licensed for, ABC and HTTC through pools. And those are public rates. A lot of implementers have licenses, through those pools, they know what they're paying. The SEP owners that didn't license through those pools are, wanting rates that are, 5, 10x what you would be paying for those same patents if they were incorporated into the pool. So as an implementer, you're saying, I have my comparable, I know what I'm paying for the vast majority of the industry that they have said is acceptable compensation for the R&D that they put in. And now the few that have held out from engaging in that process, oftentimes waiting for years until the standard was widely adopted by the industry, then they're gonna jump in and try and demand rates that are many multiples higher. And oftentimes, the patents just don't justify those rates. There's really nothing that justifies it other than I can get an injunction in Germany, in the UPC, in Brazil, before you can get a court to tell me that this rate I'm charging is
Okay, so maybe just to take stock a little bit of where we are. So we have discussed the fact that the theoretical questions, what is FRAND and what is FRAND meant to achieve, haven't really been resolved, or like they're not underpinning the specific decisions that are being delivered nowadays. So there's almost like a broken link between the way the cases are decided and the way economists have written about what FRAND actually means. But that's not something that seems to be about to change in the near future. So right now the debate is really squarely on trying to implement that concept of FRAND is what the market bears, and so it's about selecting the comparables and interpreting the comparables and making adjustments to the comparables where they are found to be defective in one way or another, and then have maybe the top-down as cross-check. So that's kind of the state of play, but then even within that solidifying state of play, we see quite significantly diverging outcomes from different courts that actually adhere to the same framework, and they probably adhere to everything we just said. I mean, it's just still the case that the outcomes can be very different. So I wanted to kind of close the panel on that last round of discussion on what are the practical implications of that outcome, that we have now, for the first time in FRAND history, two recent decisions from two different courts on the FRAND rate determination, which just come to different outcomes. People seem a little bit puzzled and perplexed what that now means. I mean, how do you take it from there? So maybe open question to all. How do you think that this is going to play out? What are the implications for that? And what would be a principled way of progressing from such a situation?
Well, I make a first observation before we come to, what does that mean and what next and how do you resolve that? Is just trying to understand why two courts have come to a different, effectively financial outcome on the determination of FRAND terms. And I think, just for the analysts, one answer might be more FRAND to range, right? And there's two reasonable sets of terms and conditions that are open to be entered into. And another answer is, well, FRAND isn't a range, or might not be a range. But just that when you put issues before the courts, inevitably you might get different outcomes because there are different court procedures, cases are argued differently, facts need to be decided, and two different courts can come to different conclusions on those facts based on the evidence before it. And we know there was a distinction in the findings of facts between those two cases, which might explain some of the financial differences. So I don't know if the panelists have a view on FRAND as a range or why otherwise there were different outcomes.
You're gonna be more provocative.
Richard's just baiting me. We had extended conversations about this, and so why do I say FRAND is not a range? First reason is because FRAND is not a rate. The contractual promise that you enter into is to be prepared to license on FRAND terms and conditions, not a rate. And so unless you are taking into account, and this is a common lecture with lawyers, so it's like, take it for what it's worth, but unless you take into account all the terms and conditions of a contract, you can't interpret that contract properly. The lazy and simple thing to do often is to try to boil the terms of a contract down to a single number and then compare the numbers between contracts. And that's just 100% mathematically wrong. You cannot take a multi-term contract and boil it down to a single number. Again, to give you an example, suppose that I'm expected to sell 10 units and I agree to pay $1 a unit. So my expected payment over the course of the license is $10. Suppose an identical person, my competitor, says, I will pay also $10 to sell 10 units, but I want to pay that up front. That's what the licensor says, yes, and I'll give you a discount. The licensee wants a discount and the licensor is going to grant one because of the shipping risk. So the licensor charges $8 for a license to 10 units, okay? What is the rate in that license? Well, first of all, there is no rate. It's an $8 lump sum payment. What judges and some economic experts will do is to say, well, I observe an $8 payment divided by $10, 10 units, and so therefore the rate, the effective rate is 80 cents per unit. That is the rate in that agreement. And so FRAND is a range. Sometimes it's $1 and sometimes it's 80 cents. That's wrong. The right way to think about this is the rate is $1 per unit. If you meet the condition that you make that payment in advance, which is another term of the contract, then you are entitled to a corresponding discount for that in exchange for meeting that condition. You get a 20% discount. That's a multi-term contract that cannot be reduced to a single variable or a single effective rate. And in my experience, it's actually quite difficult to get courts to accept even that simple principle, much less when you're talking about very complicated agreements that may have 10 or 12 significant terms, all of which affect the total payment, and which people just want to reduce to a single number, and then observe that number rate varies and call it a range. It's just not right.
John?
You knew I was jumping at the bit. I feel continued discomfort because I'm largely in agreement with John. And the thing that's a bit ironic about that is 10 years ago or so, we were in violent disagreement on this point. John's position hasn't changed over time. Mine has. And that is, I used to think that you could look at an effective rate. And he said in no uncertain terms, that's crazy, Mr. Jarris. And he's right. Looking at an effective rate can be useful. But when thinking about a FRAND commitment, I agree with you entirely that it's not just about what the rate is, but all the terms of the contract. And ZTE Samsung is reminding us of that by talking about these non-FRAND factors. What impacted the negotiation? I like to think of the result of a resulting license as being arising from transaction motivations and transaction terms. And one has to consider all the motivations and all the terms, minimums, volume discounts, all that kind of stuff I think are absolutely critical. And I think it's a misdirection for us just to be looking at a rate or a stated rate in a particular contract. So I do agree with you. I don't agree with you that it's necessarily that there's one rate, for the simple reason that it's exceptionally difficult for me to quantify the unquantifiable factors.
I would just add to say that by and large, what implementers are doing in the recent push isn't saying, I want a FRAND rate set. It's saying, I would like a FRAND license to be set by the court. That includes all of the terms that I am entitled to as a licensee. So I want to look at not just, how much money you're getting paid by your existing licensees. I wanna see, do they have, defensive termination provisions? Do they have standstills for certain, was there a patent transfer that went along with this contract that we need to, reduce that value depending on which way the patent transfer went? They're trying to get to, at the end of the day, I need to know how much I want to pay. That's what the valuable information is, but they're not just asking for a rate, they're asking for the entire terms of the contract, and that does start to factor in, not every companies are gonna be in the same situation, and the contract isn't always going to be the same between, two competitors, they might have different business interests, but you can get a lot closer to modeling the existing licenses when you're asking a court to set the terms of a FRAND license, not just FRAND rates, and that is by and large what's happening today.
So, taking moderator prerogatives to answer Richard's question. Given that you are taking moderator prerogatives, I'm taking the panelist prerogatives. I agree that it would be wrong in your example to just divide 10 by 1, or 1 by 10 and say the rate is 0.10, ignoring the value of time, ignoring the risk and so on. But I don't agree that this means that deriving an effective rate is fundamentally wrong. I think you just derive an effective rate that reflects the value of time. You derive an effective rate that reflects the value of risk. And obviously there are different assumptions, there are different ways of doing that. You come to different outcomes. And the more assumptions you have to make, the more uncertainties there are. All this comes to Richard's questions why there are different answers in the first place. But none of that leads to the conclusion that it's fundamentally wrong to try to do that. I think it's actually inevitable to try to do that. I mean, otherwise you don't have any comparables to work with at all. And I also think that there is a range. I think that it's possible for any contract with its specific terms to have a range of different rates that are FRAND, but I don't think that the reason why we're seeing different rates in different courts for some things is because there's a range. I think that the fundamental reason is because different reasonable courts have looked at different facts, because parties have driven different cases in different courts and brought different facts to the courts, and they have interpreted these facts differently, and that's just a fact of life, and that's just how courts work. And I think it's not fundamentally a symptom of a broken system. It's something that will always happen when you will have complex disputes adjudicated by courts, and I mean, there's just a big range of, and that's here, I mean, not the FRAND range, but I mean basically the range of reasonable answers to exactly the same question. And then, for example, you could ask different people about, okay, there is a range, but what is the top of the FRAND range? So tell me what the top of the FRAND range is, and the answers to that question themselves are a range, depending on how people deal with these different assumptions and choices that you need to make. So I mean, I think there's a lot to unpack, but I mean, so thank you for taking over as a moderator. You're doing a very good job. But maybe let's turn to the second question, which is the more institutional question. So we are, for whatever reason, we are now in that situation where there are different things that, and it's most likely going to be a recurrent phenomenon if things are continuing to evolve the way they are going. So it's a good moment in time to ask, what should we, or can something be done about that? What should be done about that? Or what will be the implications of nothing being done about that?
I've just got a first observation on that. First is on the SEP dispute itself. I do wonder whether those circumstances, with two courts determining global FRAND terms effectively simultaneously, will actually happen again. On that dispute itself, I think how that gets resolved is just a matter for the parties and the particular relief that the courts will now grant following the decisions. But whether it will happen again or not, I don't know. And it comes back to the Nokia dispute. I think there is a lot of power now, or it's been clarified by at least the court in the UK, that the SEP owner has a lot of power in terms of the choice of jurisdiction for resolving these disputes. in a way, it comes back to the FRAND framework. Of course, it's basically saying it's inherently part of the standard setting organisation process that the SEP owner retains that power as to decide effectively which jurisdiction a FRAND rate would be determined, in that case between the UK and an arbitral panel. So I think that strategy will now play out, such that the SEP owner will decide if there is going to be a FRAND determination, where it wants that to happen, and that will be the single venue.
Ryan or others, do you have observations on that? This is going to be a bad answer as a litigator, but this would be a great time for the standards bodies to really take a close look at whether they need to have any clarity as to what the FRAND commitment means from an economic perspective. I mean, the fact that you have multiple courts looking at what a FRAND rate should be, coming to very, very different answers, would be a good indicator that that question needs some clarity. Now, the practical realities of whether there's a willingness from the members of these SSOs to actually clarify that. I mean, we went through the process at the IEEE, and that was very messy, being reversed in large part. So there's pluses and minuses to that approach, but I think that certainly needs to be at least part of the consideration when trying to reconcile the practical realities of courts view this very differently, and oftentimes just don't have clarity on what the FRAND means.
So we have now, I think, a proposal in ETSI to encourage ETSI to revisit its IPR policy to make more explicit acknowledgement of arbitration as one possible way of resolving disputes. We have PMAC in Europe, the Mediation Arbitration Center that opened its doors, and UPC offered an opinion, basically inviting the parties to of sensitivity to use the PMAC to resolve the dispute. We have Nokia-S that are giving very strong impetus for cases to move to arbitration. So are we converging on a fundamental shift out of the courts to arbitration? And is that a good thing? Is that gonna make things better? Are arbitrators gonna make these more informed determinations that Jonathan was asking for, and avoid the many mistakes that the judges are making? What are your views on that?
Arbitration frightens me slightly. I see the short-term gain. We can resolve things quickly. I see long-term pain because there's less information to innovators, to implementers, to patent owners, to economists, to litigators. It's private by its nature, and so if you believe one of the goals of FRAND is to give some certainty to operating companies, it seems to me that arbitration gets a long way away from achieving that.
I would just say that I testified obviously in court and before arbitrators, and I think that the problem with arbitration is that if you get a bad result in an arbitration, then that's kind of a one and done thing. It's confidential. It's you got hit with a big award or a small award or something like that. In the FRAND context, a bad arbitration award follows the parties around from litigation to litigation and negotiation to negotiation. And in fact, it sets a precedent, so people can say, I want the same rate or terms and conditions that the arbitrators awarded in that arbitration. And since there's no review of the arbitration, the award takes on much greater significance to a licensing program than it normally would if it was just an ordinary commercial arbitration with a single result. So that to me is I don't think it's a panacea. And the more structural reason for that is because I don't think that there is a common set of economic principles that arbitrators or judges are bound to. So one of the beautiful things about law is that it evolves slowly, and you can see it evolving in different jurisdictions, and you can see how it fits in with larger constitutional principles and principles of justice and that sort of thing. You you're not getting the same kind of thoughtful incremental progression in setting FRAND terms and conditions. You're getting people with violently different ideas about what should be happening in different jurisdictions, and there's no real check on it. It's developing in parallel. So, what's an example? I testified in the Interdigital Lenovo case. If you read that case, you know that the judge criticized Lenovo, or criticized Interdigital, and refused to accept certain aspects of Interdigital's licensing program on the grounds that the volume discounts that Interdigital granted were a pretext, basically, when it came down to it. The judge just didn't believe that you could offer a 70% discount off of your rate if your volumes were large enough. That's so. And the judge said, well, I think some discount might be okay, but 70% is too big. Well, that's just, I got up on the wrong side of the bed. I got no principles for determining what a volume discount should be, at all, and just disregarded the firm evidence. This was, in fact, how the license were made. So all this to say is that you have many, many examples of this from jurisdiction to jurisdiction where people don't have a principled basis for arriving at quote unquote the FRAND rate or FRAND terms and conditions. And so you're going to reach contradictory results, and it's going to happen over and over again, mostly because, to be frank, lawyers don't know how to do this very well. That's what it comes down to.
Lawyers, defend yourself.
You understand who's here?
I work with it. I try to help.
Disregarding that comment, I think there are some real practical considerations for arbitration that are different and disadvantageous for the parties compared to a court. One is you usually get to pick your arbitrators. Typically each party is picking one arbitrator who then nominates someone to head up the panel. It depends on the exact structure, but you get to pick your arbitrators, you get to pick your judge in almost all cases. And so there's a fear that as these arbitrations grow more popular, you will see SEP owners nominating an arbitrator who leans heavily toward the SEP owner view of the world, implementers nominating an arbitrator who leans heavily on their side, and it's going to be almost like a capture issue of everyone has the people in their camp, and you're not really getting any sort of fair, and just no one's looking at it from kind of a neutral perspective that you would expect a judge to take. There are also concerns about discovery, third-party discovery, and discovery of licenses that are subject to third-party confidentiality obligations plays a massive role in FRAND litigation. I mean, all those comparable licenses, negotiations that they may have had with patent pools or other parties that didn't end up signing a license. All of those are often subject to confidentiality clauses that say you can't use it in things like arbitration. And in a court, you could compel them to produce it, compel a third party to produce documents that you think might be relevant to determining a FRAND rate. Arbitration has much less of a pathway to compel that same level of information. And this goes back to that information asymmetry I was talking about earlier, where as an implementer, you don't know what the good documents are, you don't know what the good licenses are until you get, production of the full set of licenses that the licensor has. And there's a concern that if you go down that arbitration pathway, you're not going to know, and you're not going to get the full set of documents, and the SEP owner can pick and choose what they think their best licenses are to disclose.
Thank you. So we should also give some time to the audience to ask questions or maybe quick reactions to some specific things that came on the panel. Matthew.
So you like